I'm Alyssa McCoy.
I'm Antoinette Merrill.
And I'm Albert Ormack.
And we are Group 2 representing our defendant, Sunshine Bank, in the case presented by Denise Jones.
Did you start already?
I did, but it's okay.
Denise Jones is a 45-year-old African-American woman who was previously employed at Sunshine Bank for 5 years. Denise has an associate's degree in finance, whereas Denise's manager, Daniel Arbor, has a master's degree in finance. Denise Jones admits that the stress has caused her job performance to decline over the time. Her termination from Sunshine Bank occurred on March 15, 2016. There were no reports or complaints of discrimination filed against Sunshine Bank by Denise prior to her termination. Jones had, however, addressed her concerns about the lack of promotion with Daniel Arbor during her employment at Sunshine Bank. Jones's initial discussion with Daniel Arbor about not getting promoted resulted in no follow-up or investigation by Daniel Arbor.
The plaintiff, Denise Jones, is filing suit against Sunshine Bank on claims of discrimination. The issues of this case are whether Denise Jones was discriminated against for promotion to the position of branch manager at Sunshine Bank, or whether Denise Jones's employment was terminated due to a visible decline in her performance at work.
The laws that are applied to determine the answer to the issues in this case are the federal law, Title 7, 1964, and State of Florida's Doctrine of Employment. The federal law, Title 7 of 1964, prohibits employers from discriminating against employees on the basis of sex, race, color, national origin, and religion. The state of Florida has a common law doctrine of employment at will. This law states that an employer can terminate an employee at any reason, for any reason except an illegal one, or for no reason, without incurring legal liability. Similarly, an employee can leave a job at any time and for any reason without any legal consequences.
In the 1995 case, the U.S. District Court, Northern District, Pensacola Division, upheld the common law doctrine of employment at will in favor of the defendant for Mary Zambori versus Digital Equipment Corp. In this case, District Judge Colley's opinion of the employment at will doctrine was made apparent when she stated that it may be cold-hearted, draconian, and outdated, but it's the law of Florida. In 2015, the United States District Court, Northern District of Tallahassee, in the case of Colleen Henry versus Republic Parking Systems, Inc., the court ruled in favor of the defendant that the common law doctrine of employment at will was a viable defense. In the summary, District Judge Robert Hinkle's statement that terminating Mrs. Henry may have been unwarranted, unjust, and a failure of management, but in Florida, an employment at will state, Judge Hinkle also states that juries are routinely instructed an employer can terminate an employee for a reason that is good or bad, fair or unfair, or for no reason at all. In both of these cases, the courts ruled in favor of the defendant with similar circumstances to this particular case.
Because of the evidence presented, there should be a complete dismissal of charges against Sunshine Bank for the lack of subject matter jurisdiction in favor of the defendant. To avoid future problems and ambiguity, we will suggest to our clients to improve their job description listings. These should include enumerating the education requirements and the skills needed to perform that job position. All job openings should be posted so that all current employees can see the positions that are available in the company. Perhaps if these recommendations were in place, Jones would not have been put in the position of confusion that has led us to this case. However, there is no evidence to support that our client is at any legal faults.
Given the evidence presented in this case, there is no evidence of discrimination. The fact that no African American men or women were hired as the manager does not mean that Denise Jones was discriminated against because she is African American. There is a total of only 50 employees at the 5 branches of Sunshine Bank, translating to very few managerial positions. Denise Jones had received pay raises commensurating with her job performance. Additionally, in the 5 years of her employment, she never once complained about or filed a grievance complaining that she was being discriminated against. Therefore, there are no clear violations of Title VII of the Civil Rights Act of 1964. Denise Jones does admit that her job performances had declined due to the stress she was dealing with about not receiving a promotion. The poor performance ultimately led to the termination of her employment. Denise Jones's decline in performance was a sufficient reason to terminate her employment. Although no explanations are necessary, it would only be illegal if she was terminated for reasons such as racial discrimination or any discrimination. While Denise Jones felt that she was qualified to be promoted to manager, there are no indications of her interest in the position until the position was filled by Daniel Arbor. Regardless of Denise Jones's qualifications, which include an associate degree in finance, Daniel Arbor was more qualified as he did have a master's degree in finance.
This project challenged us to work as a team to understand what goes into making a case for and against a defendant. It also opened our perspective to working with different types of personalities and techniques to reach our goals. We did not seem to encounter any conflicts, but we were challenged to do our best work as a team collectively. We learned that the laws involved in this case are important and valuable to businesses and workers alike. They are also closely related to the human resources side of the business decision-making process.
Is the list of references we used in our presentation. The cases we used were used under slide 6 for the previous court rulings. Thank you so much for watching.